All right, everybody, welcome to our third episode in the saga that is SB-1079. A couple of housekeeping matters before we get started here. There'll be a Q&A box in which you can submit your questions. Do not submit them into the chat, otherwise I won't see them. We'll allow, I'm aiming to allow 10 minutes or so to answer any questions you guys might have at the end. If any of your questions are maybe a little bit longer, or maybe take a little bit more time to address, you can also email me at Jacoby Perez, j.perez at jurassillp.com. There's my contact information on the initial slide. We'll be sending these slides out as well after the webinar concludes, along with the recording. The contact information will be there as well. I'm Jacoby Perez, a litigation attorney with Jurassi Law Firm. Today, we're going to be talking about AB-1837, which is, we're now in the third year of dealing with SB-1079. We did an initial webinar at this point a couple of years back, kind of looking at what SB-1079 stood to change in the landscape of non-judicial foreclosures. And as I would say, we rightly flagged very early on, there were a couple of pretty big potential litigation pitfalls, particularly surrounding some of the vagueness in the way the concepts were defined around who's an eligible bidder, who's not, and also surrounding whether the statute really had any teeth to enforce some of the definitions that, or enforce some of the requirements that it was seeking to impose. So then we looked at in a second webinar some of the changes and I would say maybe halfway measures that the legislature sought to put in place for the second year. And essentially, they're just, although there were a lot of problems that both we as litigators and people that are in the space saw popping up around SB 1079, there was just a lot of uncertainty about, with such a new law, how these things were going to work their way through the courts, how we were going to get determinative rulings on some of these litigation issues. And the legislature kind of took a halfway approach after the first year, addressing only what I would consider minor, somewhat procedural issues that were kind of glaring problems, and holding off on getting at some of the bigger issues that were kind of staring us in the background. So in this third webinar, as we're going to see for the year of 2023, this legislature has implemented a substantial overhaul to the SB 1079 process, particularly surrounding how it's going to define what an eligible bidder is, and with respect to entity bidders, what an entity bidder can do with an SB 1079 property once it acquires it. So, the major topics that we're going to touch on today, particularly with respect to the new law, we'll briefly run through what SB 1079 is and some of the fundamental requirements that it brought, the fundamental changes that it brought to the foreclosure process, to kind of just lay a quick framework so we can compare it to what AB 1837 does and how it changed that initial framework that was put in place. And even just looking at what SB 1079 did initially, it's important to note that one thing AB 1837 does is it extends SB 1079 into 2031 at this point from 2026. So the main things that AB 1837 does to bring change to the current scheme that we have, the first, as I kind of touched upon, is clarifying some of what these entity eligible bidders mean. And it does it kind of twofold. One is on the definition end, where it seeks to tie the entities more closely to California, and also to the affordable housing type space, And then we'll look at the second way that they try and do that, which is I mean, I would consider even maybe a drastic measure, which is the AB 1837 implements a 30-year affordability covenant on properties acquired by certain entity eligible bidders at these foreclosure sales, which restricts the property to either be sold at affordable housing prices or rented at affordable housing prices for that 30-year period, as defined under the Health and Safety Code. A kind of third secondary measure that AB 1837 introduces, we talked about how the big problems early on was the defining the categories of bidders, but B was whether the statute actually had any teeth. And we see now the legislature trying to get at that here by actually creating an explicit enforcement mechanism through the Attorney General, by which the Attorney General can actually prosecute cases, SB 1079 cases on its own. Now, that's interesting for a couple of reasons that we'll touch on, whether it's explicitly the Attorney General going after these, or, in a lot of my SB 1079 cases, an unfair business practice 17200 claim gets raised a lot, under which there is an attorney's fees provision for if you step into the shoes of the Attorney General to prosecute an action seeking to prevent an unfair competition, to enjoin unfair competition that's out there. So it's interesting that we see the legislature trying to add more teeth to the SB 1079 process. And lastly, we'll just briefly take a look at what I thought is, and it's not explicitly SB 1079, but it's still the legislature trying to get at this issue. And at this point, kind of from the other end of the spectrum, AB 2170 actually requires these institutional foreclosure entities that foreclose on over 175 properties a year to provide a 30-day window for any REO listings in which only offers by certain eligible bidders may be accepted. So on the other side of the foreclosure sale, when these particular type of entities require it or acquire an SB 1079 property, there's a 30-day window in which they can only offer it to eligible bidders to give them preference kind of on the other end. So that said, quickly, here's a slide of the agenda. We don't need to go back through it. I just ran through it all there for you. So what is SB 1079? For those that don't know, I would expect most would that are tuning into the webinar at this point have at least heard about some of the problems that are surrounding the statute that we've been grappling with. SB 1079 went into effect January 1, 2021, and the idea was legislature was concerned that we were going to have a wave of foreclosure similar to the Great Recession, in which we were going to see transfers of properties. Once the COVID restrictions were lifted, transfers of properties from individual ownership to institutional investor type ownership. So the idea was, okay, let's modify our non-judicial foreclosure process to provide certain advantages to the types of individuals and even maybe entities that we would prefer acquire these properties. So, at least give them a level playing field over these institutional guys, and hopefully kind of get out ahead of an anticipated problem of seeing properties continue to be consolidated in the hands of institutional investors over individual ownership. So how does SB 1079 seek to accomplish that ideal of what we would call promoting owner occupancy? Well, for one, it's limited to residential properties in which that can be owner occupied. It's limited specifically to properties that contain 1 to 4 residential units. Another important limitation SB 1079 brought was a limitation on sellers bundling the homes together during the foreclosure sale. Because again, an individual bidder is not going to be bidding on bundled homes. He's seeking to move into a single foreclosed property. So you had that prohibition on the bundling. And then finally, which is kind of the real meat of it and where we saw the major changes, but also the major problems, was this 45-day window that potentially kicks into gear after you have a trustee sale. So prior, when you would have a non-judicial foreclosure trustee sale, that would be it. You would have the bidders at the sale, and the highest bid property goes to the highest bidder. Now SB 1079 introduced two new potential situations. One is which, if you have an eligible bidder as defined under SB 1079 at the trustee sale, then that's it. The sale occurs as it would regularly, and it goes to a prospective owner occupant or eligible tenant buyer. There is no 45-day window. However, if there's not a prospective owner occupant or eligible tenant buyer at the highest bidder at the trustee sale, then you have this new 45-day window that's implemented, in which other categories of eligible bidders can submit a bid and potentially become the owners of the property. So, we'll take a quick look at how that process works, but it's essentially they have to submit an affidavit within 15 days, perfect their bid within 45, including tendering the funds, and the highest eligible bidder at that point generally is the one that takes the property. So what are the categories of eligible bidders? The first category, and it'll be important to keep this definition in mind when we look at some of the new changes AB 1837 brings. But the initial category that you have, it's not the most usual one, but an eligible tenant buyer, and that's someone who already lives on the property, wants to buy the property. So they occupy it as a primary residence at the time of the sale. They have an arm's length lease agreement. And they're not the borrower's family member, which again speaks to that sort of arm's length issues. Now, they're not the most common problem or not the most typical litigation issue that we've seen. However, I've definitely seen cases where you had certain questionable individuals claiming to be eligible tenant buyers trying to meet these requirements, because an eligible tenant buyer has certain advantages over all of the other entity type bidders, in that an eligible tenant buyer, as we kind of touched on a few minutes ago, if they're the highest bidder at the trustee sale, there is no 45-day window. Even if you are an eligible bidder type entity and you're the highest bidder at the trustee sale, you're still subject to that 45-day window. So there's a major incentive to be an eligible tenant buyer, or as we'll see, a prospective owner occupant. And when we take a look at AB 1837, we'll see some of the stricter requirements that the legislature put in place on these eligible tenant buyers. Prospective owner occupant is sort of your typical scenario. Rather than someone that's already living on the property, it's a prospective homeowner who wants to acquire the property. And the requirement is that he's going to occupy it as his primary residence within 60 days after the trustee's deed is recorded, going to live on the property for at least a year. Again, there's an arm's length situation in that he's not the borrower or the borrower's family member, and he's not acting as the agent. Essentially, he's not the straw man for any other person or entity that's buying the property. He's a bona fide prospective owner occupant. And the way I look at it is, this is kind of the legislature's ideal situation, short of an eligible tenant buyer, where we're making sure that homeowners are acquiring the homes rather than they end up going to investors who may or may not decide to use it for affordable housing or the purposes that the legislature envisioned. And so then we'll briefly take a look at the additional categories of eligible bidders under the prior law. As I mentioned at the outset of here, AB 1837 tweaks, especially the type of nonprofit corporations that can qualify, tweaks the definition significantly and imposes a few new important requirements on them. But we'll take a look at the general language here just to illustrate how vague it initially was. And you can really see as you parse and ask, okay, well, what does that mean? What does this mean? Why AB 1837, and really that need or that reaction, or maybe even overreaction of imposing this 30-year affordability covenant became a necessity. So these entity type bidders, the kind of first one is a nonprofit in which an eligible tenant buyer or prospective owner occupant is a voting member or director. So in that case, I mean, you still have an eligible tenant buyer or prospective owner occupant involved. The situation is not as ideal as having one of them move onto the property because they just have to be a voting member or director. They're still restricted though by those definitions. So this one was kind of just a strange category of, I mean, I guess if you're for tax purposes or something, prospective owner occupant wanted to use it. We'll see AB 1837 kind of does away with this category as well. The next one, the first area that's kind of problematic was an eligible California nonprofit corporation whose primary activity is development and preservation of affordable rental housing. So what does it mean for your primary activity to be the development and preservation of affordable housing? How long did you have to have any transactions at all within this field? How long would you have to have been in this field? What filings were required with the California Secretary of State to establish you as one of these corporations? I mean, the language says eligible California nonprofit corporation. What exactly does that mean? Then you had another category related to this one, which is even more removed, one step removed, in which a limited partnership or limited liability company in which the managing general partner or managing member is that California nonprofit that we just identified in the prior category. So now we're getting even further away from California, getting even further away from whatever that definition means of having to have your primary activity in the development and preservation of affordable housing. So you can see with these nebulous categories how they could be problematic if you're trying to enforce them in the context of litigation. The huge thing that SB 1079 does is that it does provide advantages if you're an entity and you're maybe an unscrupulous investor. There's definitely advantages that these entities have over just regular investors. Regular investors are only able to bid on these properties at the foreclosure sale, at the trustee sale. So rather than having to engage in a competitive bidding process, you can simply, assuming you meet the category of eligible bidder, or at least are willing to claim that you do, you can wait till that trustee sale plays out and just overbid that bidding process at the trustee sale and be determined the prevailing bidder. Which, on top of that too, you don't actually have to have your money tied up in that trustee sale. You can choose to tender the funds at the end of that 45-day process. Another advantage that these eligible bidder type entities would have. There's a couple of other categories that were defined in the code that they don't come up as often or aren't as significant for AB 1837 analysis. So we'll send out the slides. You'll be able to take a look at them later on. What is an eligible bid? And this is briefly just getting at the process that has to be followed in order for the eligible bidder to be considered. If there was no highest POO or eligible tenant buyer at the trustee sale, then if within 15 days an eligible bidder submits a written notice of intent to place a bid, then this 45-day window is into effect, assuming that written notice is legitimate and, as became the law last year, has to be accompanied by an affidavit sworn under penalty of perjury. Law says trustee may reasonably rely on this affidavit. And last year, they also kind of clarified, the timeline, the specific timing of when the trustee must receive the affidavit, and also when they must receive the bid, which is, the amount, which is 5 p.m. on the 45th day after the trustee sale. So there's a couple of special provisions, you could say, that apply to prospective owner occupants. We kind of touched on them already. You'll have this slide as well, but the big one is if you're an eligible tenant buyer, eligible bidder, and you're the highest bidder at the trustee sale, there is no 45-day window. The other one that doesn't really come up as much just because eligible tenant buyers aren't as common, but multiple ones is even less common. But they can actually submit a bid equal to the amount of the last and highest bid at the trustee sale. And they don't actually have to exceed the highest bid at the sale. But also, if the eligible tenant buyers, if all of them actually agree, they can submit a bid on behalf of all of them that immediately becomes the winning bid within the 45-day window, and the 45-day window does not have to actually go to completion. The eligible tenant buyers who submit a bid on behalf of all of them would be granted the property, assuming they match the highest bid at the trustee sale. So getting to what AB 1837 brings to the table, the changes that it brings to the categories of bidders. The first thing that we kind of mentioned is this SB 1079 process has been extended. It's been extended from January of 2026 and now is anticipated to run through January 2031 as the current law stands. So ostensibly, the legislature sees quite a lot that they like about what SB 1079 has been doing. But for some of the dramatic changes that we will see implemented and we'll be talking about going forward. So some of those changes that are going to remain in place are specific notice requirements that we haven't really touched on for litigation purposes, but there are very specific notice requirements that are iterated, down to the T in the code that have to be followed in order to conduct a sale under SB 1079. The interesting part about that, is a little bit of an aside, is our non-judicial foreclosure process. The idea is that, okay, on one hand, we want to allow an efficient economic remedy for foreclosure in the event that there are defaults. But the way that we're going to make sure that it's a fair process is that it's going to be highly regulated on the ends of the requirements that we impose. And so we had this, body of law that was very particular about the requirements that were going to be implemented. Now, SB 1079 comes in and introduces this window of this 45-day window, and I would say a window of uncertainty, where what some of these property rights mean might come into question. It's something that certainly comes up a lot in just at the pleading stages of some of the litigation that I've been dealing with. Is there a property right created by the bidder who's bidding at the trustee sale? Particularly when now under SB 1079, he tenders the funds at the trustee sale, and you have an eligible bidder that comes in after the fact, and now that investor bidder at the trustee sale has his money tied up for the duration of that 45-day window. It would seem to me that there's at least some sort of quasi property right created there. There's definitely a detriment being incurred by that investor. And assuming certain conditions are met, he's obligated to those funds are he's going to be deprived of those funds, and he's going to acquire the property. So it introduces this new element of uncertainty regarding how we look at some of the causes of action that might be brought in relation to SB 1079, whether we're talking about a general quiet title, potentially with these fraudulent bidders, an intentional interference with prospective economic advantage, whether there's a breach of contract or even a promissory estoppel issue. There's a lot of questions for judges still to decide surrounding the exact nature of these property rights and how this SB 1079 window really should fit within the types of claims that we have currently available to us under the case law. So with that said, start looking at some of the changes that AB 1837 brings. An eligible tenant buyer, as we talked about, someone who occupies the property as their primary residence. Now, what we see AB 1837 do is impose some stricter evidentiary requirements and an interesting bankruptcy requirement as well. So if you look at the specific language, An eligible tenant buyer must be occupying the real property under a rent or lease agreement entered into as a result of an arm's length transaction with the mortgagor or trustor, or with the mortgagor or trustor's predecessor in interest on a date prior to the recording of the notice of default against the property, and who attaches evidence demonstrating the existence of the tenancy to the affidavit or declaration required pursuant to this subparagraph. And we'll take a look at what that definition is. That was not a requirement before for an eligible tenant buyer. So, this isn't the biggest change that AB 1837 brings, but if you are an eligible tenant buyer, and the ones that I've spoken to, that I've advised to up into today, I suggested that they do this anyway, that they attach a copy of the lease agreement to their bid. As we recall, the law allows the trustee to rely on the affidavit anyways. However, whether in the past it was better safe than sorry, now it's very explicit that you have to attach evidence demonstrating the existence of the tenancy. So what is that evidence? If you take a look at this bullet point 5 we have here, evidence demonstrating the existence of the tenancy means a copy of the dated and signed rental or lease agreement, or if a copy of the dated and signed rental or lease agreement is not available, then either A, evidence of rent payments made for the property by the person asserting that they are an eligible buyer for the 6 months prior to the recording of the notice of default, or copies of the utility bill for the property payable by the person asserting that they are an eligible tenant buyer for the 6 months prior to the recording of the notice of default. So again, we see the legislature trying to tamp down on how we can actually enforce these previously more nebulous categories of what's an eligible tenant buyer, what's an eligible bidder, imposing stricter requirements that are verifiable, whether that ends up having to be, by the attorney general, or it ends up having to be by the judges in litigation. And I touched on this briefly, but there's also this new requirement that an eligible tenant buyer cannot be someone that filed a bankruptcy from the date of the trustee sale through that 45-day window. If they file a bankruptcy before, ostensibly it stays the foreclosure process anyways. So this new requirement, I guess it requires them just to pick or choose. What are they going to do? Are they going to file bankruptcy, or challenge the foreclosure in some other way, including trying to be an eligible tenant buyer? But you can't have it both ways. You can't file bankruptcy and also claim I'm going to be an eligible tenant buyer. And so now we're going to take a look at the significant changes that AB 1837 brings to the definition of the eligible nonprofit. As we saw, we'll take the prior slide, a quick look. A nonprofit in which an eligible tenant buyer, prospective owner, operator is a voting member, director, an eligible California nonprofit corporation whose primary activity is development and preservation of affordable housing. That's the extent of the definition that we're talking about here under the prior SB 1079, or a limited partnership or limited liability company in which you have one of those California nonprofits. So let's take a look at what the new code says. The new code says an eligible nonprofit should have the following attributes. One, now we see a definition ostensibly of what eligible means. There has to be some existing paper trail to evidence that this nonprofit is what it says it was. And here that's a determination letter from the IRS affirming the tax exempt status of the nonprofit pursuant to 501c3 of the Internal Revenue Code. And that it's not a private foundation as that term is defined in section 509. So that's interesting because now you have a requirement that the IRS actually determine that determine the category of nonprofit that you're trying to seek under. You can't just say, oh, I filed a statement of information with California. I'm a nonprofit for purposes of this section. My bid needs to be considered. over all those other investors who, don't do affordable housing. I definitely do it. I said it in my papers. Um, a second requirement we see, the nonprofit has to have its principal place of business in California. Um, the primary residence of all board members must be located in California. And so those two are significant changes from what we've seen in the past. Now, in this fourth one is kind of interesting when you think about it. It isn't a dramatic change from the language, and even though the language wasn't great under the prior definition, you'll see why there wasn't a need for a dramatic change here. When it says one of its primary activities is development and preservation of affordable rental or home ownership housing in California. Now, it's still not perfectly clear what exactly that means. This actually ostensibly expands the relevant categories of nonprofits because it just says one of its primary activities, where the last one said its primary activity. The last law said primary activity was in the development and preservation of affordable housing. However, as we're going to talk about shortly hereafter, this is coupled with, if you are one of these entities meeting these definitions, acquiring the property at the foreclosure, there is a substantial restriction on your use of that property. And that's where we talk about that affordability covenant. So while this ostensibly says, maybe this is an expansion and only one of your primary activities has to be the development and preservation of affordable housing, meaning more entities might be able to qualify under this requirement. When you look at the use restriction, there is a heavy disincentive for any of these potentially fraudulent bidders to want to try and qualify under these categories. Up until seeing AB 1837, that is a huge issue that we've seen coming up, is with these definitions of, what is a qualifying nonprofit? What does it mean to be in affordable housing? There's all these incentives for them to try and shoehorn themselves into one of the entity categories and be able to swoop in and take the property after the foreclosure sale. But now, when we look at this affordability covenant that gets tacked on, there's really no reason, there's no incentive for them to do it because they're going to be restricted to using that property for affordable housing for, ostensibly 30 years. And then we see another change to the type of entity bidder. We talked about what the nonprofit was. As far as the changes to the limited liability company, this says a limited liability company wholly owned by one or more eligible nonprofit corporations as described in subparagraph C or D. So this is a significant change too. Again, when we look back at what we had before, we had a limited partnership, which we don't see anything mentioned about a limited partnership anymore, but also a limited liability company in which all that was required was the managing general partner or managing member must have been one of these eligible California nonprofits. When we look at what the new law says, it's not just the managing member, it has to be wholly owned by an eligible nonprofit corporation, and not an eligible nonprofit as defined under that old law with those more broad definitions. An eligible nonprofit that meets this IRS determination, principal place of business in California, all board members have primary residences in California, and is registered in good standing with the Attorney General's Registry of Charitable Trusts. So, as we mentioned, we had the big changes brought to the definitions of eligible bidders. Here's kind of the most substantive change that AB 13.7 introduces into the playing field. Obviously, there's a lot of text here. Oh, apologies. There's a lot of text here, but the key here is that for one of these eligible bidders, which this refers to these types of entity bidders that we've been talking about, acquired one of these properties at this type of foreclosure sale, non-judicial foreclosure sale, subject to SB 1079, The property shall be subject to a recorded covenant that ensures that the property shall be sold at an affordable housing cost, which is defined under the Health and Safety Code, or rented at an affordable rent. Again, specific definition, no longer dealing with these uncertain nebulous definitions, specific definition for lower income households for 30 years from the date the trustee's deed is issued, or a greater period of time potentially if some of these other exceptions apply. And you can see them listed there, they'll be there in the slides. But this is critically, I mean, this is a hammer to that type of what I would consider unfair business practices that we had seen, these unscrupulous entity bidders trying to pull under the prior law, where they're looking for a loophole. We've seen, not only did the legislature say, okay, we're going to change the definitions and make that more difficult, which, I'm sure if that had been the only provision, we would still see, certain entities trying to work their way around the statute. Obviously, the language that we started with in the beginning, not great. They're still trying to fix it. It's still, in my opinion, there are a lot of holes in it. But this here is unambiguous. If you claim to be one of those eligible bidders, regardless of, the nuances of how you claim to get there, you're going to be restricted to using that property. So it doesn't matter, regardless of what it means, you're in affordable housing or not, what category that you're meeting, you're one of those entity bidders as defined in the prior section, you're restricted to this affordability covenant. What that does is it entirely deprives the incentive to acquire this property. And what we were seeing, these entities claiming to be eligible bidders, not using it for that purpose, and instead turning around, getting a cheap foreclosure property, turning it around, fixing and flipping it, making a great profit. That's no longer an option here. That's being taken off the table. On top of that, if it wasn't clear, now it's not just going to be left to the, us litigators to fight out, okay, well, how do we enforce any of this in court? How are judges going to come out on it? Especially some of the individuals affected, may not have the money to bring a lawsuit and fight this thing all the way to, even if it has to go to an appellate court to get a decision on some of these issues. So on top of having that kind of hammer restricting the use, now we also have the threat of the attorney general being involved. And there's a couple of ways that this new AB-1837 tries to bring the attorney general into the fold. So what the language says is that the attorney general, a county council, a city attorney, or a district attorney may bring an action for specific performance or any other remedy at equity or at law to enforce this section. Now, that's very broad. I mean, obviously specific of performance, but what does it mean? Any other remedy at equity or at law to enforce this section? To me, that signifies extremely broad power for the attorney general or, some of these other government actors charged with, enforcing these statutes to bring causes of action, trying to get the offenders to fall in line. What the most common thing I heard, the last couple of years was, people having questions about SB-1079, telling me that, they've been in constant contact with Nancy Skinner's office, trying to get some sort of guidance. How do I refer things to the attorney general? Can they even do anything about it? What are my options here? There's someone out there that's committing fraud, and how do I stop that from going on? Just as a concerned citizen. So the interesting part that you have here is we touched on how, some of the civil causes of action and there's all these uncertainty because of the new law and how the causes of action don't completely line up with what we had in the system before. And these things need to work their way through the courts. we have an alternative means of imposing the requirements under AB 1837 now, which is an enforcement action by one of these government actors. And that really is a theme that we see throughout this AB 1837. I mean, we took a look at the expansion of the affidavit and the declaration requirements for an eligible tenant buyer, and how they, we talked about having to post either the lease agreement along with your affidavit, or at the very least, submit rental payments or utility payments. We saw the restriction of the definitions of entity eligible bidders, really contracting the what types of nonprofits were going to be eligible here. They needed an IRS determination. They needed to be tied more closely to California than before. And then obviously, what I referred to earlier as the hammer, which is this 30-year affordability covenant, restricting use no matter what else shenanigans goes on with respect to the eligible bidder claims. And as part of this, to encourage these attorney general actions, there is a new reporting requirement under AB 1837 that the trustee, now once you have one of these SB 1079 sales, actually has to provide the attorney general with certain information surrounding the date of the sale, identifying information of the prevailing bidder within 15 days of that sale actually concluding. Ostensibly the purpose being allowing the AG to track a little more closely and in line, ostensibly with this agenda to encourage the type of enforcement that we're talking about here. I mean, we have cases where we've got one guy who's claimed to be a prospective owner occupant in 13 separate foreclosure sales. If you recall, a prospective owner occupant says, that's going to be my primary residence. I'm going to move in within 60 days. I'm going to live there for a year. In the past year and a half, he said that for 13 different sales, which is obviously repeated instances of affidavits being submitted, fraud upon fraud upon fraud. This new mechanism requiring the trustee to report those types of winning bidders, hopefully, assuming the AG is listening to the many complaints that are being forwarded up there, hopefully will prevent some of those situations going forward in the future. A couple of other just quick, more minor changes that come along with this AB 1837. Just wanted to briefly touch on. There's a clarification with respect to the affidavit that's submitted by an eligible bidder, that it's actually a non-binding written notice of intent. So you're not, even though you submit within 15 days, your affidavit saying I intend to tender these funds, that's not actually binding. I haven't had that case before me, but I'm sure it's out there. I'm sure somebody's litigated it. The trustee may reasonably rely on affidavits. We talked about that. A new requirement associated with that now is that the affidavit or declaration of the winning bidder actually has to be attached as an exhibit to the trustee's deed when it's recorded. Not a big thing there, but when this litigation props up, the first thing that arises, on my end, especially if it's someone who feels they've been defrauded by an eligible bidder, is, okay, well, we need the affidavit because we're going in for an injunction preventing any further exchange of the property. Well, if you can't get the affidavit, it's a little bit harder to prove the judge that you deserve a TRO, you deserve an injunction. Now that affidavit, rather than having to wait for discovery or subpoena to have to work its way through the system, that affidavit has to be attached to the trustee's deed. And also, it's more transparent. It makes it public information, makes it easier for everybody to track what's going on with these entity bidders who are claiming to meet these eligible bidder categories. Another clarification we have here: prospective owner occupant shall not be in violation if a legal's owner compliance with the requirements of 2924N renders them unable to occupy the property as their primary residence. So you kind of have an interesting concession here, and as we'll see with the next kind of clarification too, is that there's a recognition of, well, what happens, when there's rights affecting the foreclosure sale outside of just the bidder and the trustee and the foreclosing beneficiary, particularly with tenants, holdover tenants. There's a clarification here, a prospective owner occupant's not going to be in violation if for some reason they're prevented from actually occupying the property. That's not a per se violation because the explicit language does say within 60 days. So just a clarification, impossibility, we're not going to hold that against you. On the other hand, tenants, if any property purchased to 2924M by an eligible bidder, may exercise any rights available at equity and law, including unlawful detainer. So just it was the case before, but a clarification. Nothing in SB 1079 is supposed to affect your unlawful detainer rights. I would say another clarification: pendency of a determination of finality under the process, under this 45-day window, and who actually is the highest bidder, is prohibited from causing termination of any hazard insurance coverage in effect at the time of the trustee sale. So I've had that question come up a couple of times, not through litigation, but just curious bidders, investors, who's responsible for the insurance on the property. Well, there's your clarification there. A final, and as I mentioned, this isn't explicitly AB 1837, SB 1079, but it's within the same spirit, enacted together, obviously the same year, seeking to accomplish a similar goal, which is AB 2170, kind of been referred to as it was working its way up as the first look law. And with that, it's limited to entities that annually foreclose on 175 or more residential real properties in California, limited to sales of real property containing 1 to 4 residential dwelling units acquired through foreclosure under a mortgage or deed of trust by a qualifying institution, or that is acquired at a foreclosure sale by a qualifying institution. Qualifying institution as defined in that first category that we mentioned, which means you annually foreclose on 175 in California. And the meat of this AB 2170 is kind of the other end of a foreclosure sale is, you get an REO and it gets put on the market. Well, now that first 30 days of that property being listed, the entity can actually only accept offers and from eligible bidders, and it must respond in writing to all offers received by eligible bidders. The purpose there, again, kind of similar to what SB 1079 is, give a little bit more of an edge to these categories of eligible bidders who might not be as sophisticated or ready to be on the ball to go after these foreclosed properties. So in conclusion, the big changes with AB 1837 we talked about, the changes to the categories of nonprofit eligible bidders and the other entities. We saw them do away with LLP. We saw that for an LLC, it has to be wholly owned by a qualifying nonprofit. Second major change, this 30-year affordability covenant, it's going to be imposed on these eligible bidder entities that acquire the properties at foreclosure sale, completely restricts the use, takes away that incentive to circumvent the eligible bidder categories. AB 1837, now we have an enforcement mechanism through the Attorney General, whereas rather than just forcing litigators to battle it out in civil court and to figure it out and wait for things to work their way down from appeals, Attorney General now has, a little bit more of a, they have a right to enforce this, Attorney General and other government actors, other certain government actors, and there's reporting requirements that have to be given to them. And we've seen, through the AB 1837, a couple of evidentiary stricter requirements on the bidders that the Attorney General can enforce in pursuing any action. And last, we talked about AB 2170, that first look, where within 30 days, only certain eligible bids can be accepted. So with that said, it looks like we've got about 10 minutes for questions. So let me pull up the Q&A and let's see what we got here. Have you participated in or heard of any successful cases of buyers who lost properties to fraudulent SB-1079 buyers who sued said buyers? Yes, absolutely. I have many of those cases before me now. Yeah, I mean, we have cases where they claim to be prospective owner occupants and instead turn around and flip the property. Prospective owner occupants where that they didn't have a chance to flip the property, but they submitted a similar affidavit in 10 other instances. We have cases where you have entities claiming to be one of those former, under the old law, nonprofits or be in the business of affordable housing, but they've got no track record with California. They've never done any business. They've never done any transactions. They're just saying it. But unfortunately, maybe the old law didn't have any teeth in order to hold their feet to the fire, so to speak. So yes, I mean, the big ones, there was kind of a theme through here. The big ones were surrounding either that prospective owner occupant who turns and flips the property, or those nonprofit categories where there's nothing that actually requires them to do anything with affordable housing. What is your liability if you cannot occupy the property within 16 days because you have to evict? I think we addressed that just a couple of slides back, but there was a clarification in this new iteration of the law specifying that if it's an impossibility that you're not able to take over the property, then you're not going to be held accountable for that. Let's see. If an eligible tenant / owner occupant fails to perform close on property in the 45-day window timeframe, does clock restart again, or can investor non-occupant purchase bid on the 46th day? No, if you have the 45-day window, and if you have the 45-day window and someone submits an affidavit, they say, I'm going to be an eligible bidder, but they never actually tender the funds, then the property, if there is another eligible bidder that does tender the funds, the property will go to them. Or if there is none, the property is going to go to the highest bidder that was at the trustee sale. There's not going to be any bid on the 46th day. It's going to go to the highest bidder at the trustee sale. The trustee may reasonably rely on this affidavit. The use of the word may suggests that there's an opening for the court to hold the trustee responsible if the eligible bidder lies and is found not to be an eligible bidder. Does that sound reasonable? This is one of those things that, if you've seen the earlier webinars, we definitely flagged this early on as, what does this mean? What degree of evidence is, especially, yes, the trustee may rely on the affidavit, but what happens when the trustee is faced with overwhelming external evidence that maybe this person is fraudulent? Say, for example, the trustee's involved in plenty of trustee sales, and the same fraudulent bidder comes up to multiple ones and says, I'm a prospective owner occupant. I'm a prospective owner occupant. Well, obviously that's an impossibility. He can't occupy all these properties as his primary residence. What level of evidence must the trustee consider against being able to rely on the affidavits that are being submitted? That's a litigation question. There's not a clear-cut answer. It's something that, it's one of those things that is gonna, I'm sure it's gonna come up, and I mean, it has come up in cases, but I'm sure it's gonna come up in some case where we're gonna need direction from the court to resolve that issue. And unfortunately, just a lot of these issues are still working their way through the courts because of the infancy of the statute. It's not clear what the answer is. It's a fact-dependent analysis, I would say. let's see. And also, guys, just to let you know, if I don't get to your question here, I mean, I'm looking through them and some of them are a little bit more lengthy. We've got 10 minutes of answering questions here, but you can always reach out to me by email. I'll have a copy of these questions as well. And we'll be able to address your questions after the fact. So feel free to reach out to me by email. What is the definition of prospective owner occupant? Any fine print conditions? There's a slide here that explicitly states what it is. You can feel free to go back and look at it, but they certify within 60 days, they're going to move on to the property. It's going to be their primary residence for at least a year, and they're not a straw man, essentially. There's an arm's length relationship, and they're not a straw man for some other agent. If a person is claiming to be an eligible bidder based on owner occupancy for at least 1 year, does the 30-year rule apply? No, because it only applies to the entity type bidders. You can take a look back at the statute that we included a couple slides back. Like I said, these are going to be distributed. There's a lot of language in there, and it cites the specific categories of definitions of eligible bidders to which the affordability covenant will apply. But you'll see that it only applies to entity eligible bidders, of which a prospective owner occupant is not. Are trustees required to be transparent about the value of offers received during the NOI period? Yes, there's a specific statute, and I don't have it offhand, but there is a section in the code that I'm not sure if it was added with this most recent AB 1837, but there's a specific section, and feel free to email me after this, and I can get that to you, that says explicitly what the trustee is required to communicate. And I know that was not a section that was initially included in SB 1079, but it is there now. So feel free to reach out to me after this, and I'll get that specific code section to you. Is the qualifying buyer required to render any funds to the trustee in the 15 days, or all funds due by day 45? I'm assuming by qualifying buyer, you mean eligible bidder. And if that's the case, no, you're not required to tender any funds within the 15 days. You're only required to submit them at the end of within the 45-day window. What you are required to submit within 15 days is that notice of intent to bid and an affidavit under penalty of perjury indicating the category of eligible bidder that you meet. And then keep in mind, we have this new requirement with the eligible tenant buyer. If that's the bidder category that you're qualifying under, you got to attach with your affidavit proof of either your loan, your lease agreement, or utilities, 6 months utilities, or 6 months rent payments. All right, guys, so it's 12 o'clock. That's all the time we have. We have a copy of these Q&As. If I did not get to your question, like I said, feel free to reach out to me. These slides will all be distributed, once we're done here, along with the recording as well. But like I said, don't be hesitant to reach out with any further questions you guys might have. And thank you for joining us. Thank you for your time.